Welcome to this Taylor Wessing webinar on the subject of the scope of protection of patent claims in Europe. My name is Paul England, and to discuss this topic I'm joined by Judith Krens, who is a partner in Taylor Wessing's Amsterdam office, and Christof Höhne, who is a partner in our Düsseldorf office. Before I start, I should just mention that you're welcome to send in questions using the option online, and we'll respond to you as soon as we can by email after the webinar, if there's not time at the end. Please also stay online for a moment at the end to fill out the short feedback form that will appear on your screens. So let me start by giving the context of this discussion, which is the Unified Patent Court, UPC, and Brexit. It is, of course, still early days in the Brexit process that began with the vote of the British people on the 23rd of June. However, in the area of the Unified Patents Court and Unitary Patent, that decision is already having an impact. The launch of the new system, which had been expected in 2017, still requires ratification of the agreement by the UK and Germany. But that UK ratification is now very unlikely in the short term, it seems, without there being any guarantee that the UK would not be asked to leave the system after the UK actually leaves the EU. Such a guarantee would require reformulation of the UPC agreement to accommodate the UK as a non-EU member, and a requirement that the UK recognises the primacy of EU law. Now, neither of those things are impossible, but they aren't going to happen quickly. And the upshot is that the UPC and the Unitary Patent project will probably face several years of delay. Gladly, though, where Brexit will make little difference, if any, is to the current European patent system. European patent is administered through the EPO, the European Patent Office, based on the European Patent Convention, which are not EU institutions. These patents are enforced in the national courts under national law. However, one of the objectives of the UPC had been to establish a uniform approach to patent law in Europe by the development of a single body of case law. Hence, without the UPC for the time being, we still have to continue with the differing approaches to patent law in different countries that we have at present. And this is where this webinar comes in, because today we want to address how the courts of three major European patent jurisdictions, Germany, the Netherlands and the UK, interpret the scope of protection of patent claims. And this is an important subject, because exactly what patent claims cover is, of course, critical for assessing whether an unlicensed product falls within their scope, and whether a party can be potentially blocked or liable to damages for its activities with that product. So the starting point for any consideration of the scope of protection of patent claims is Article 69 of the EPC, the European Patent Convention. This article states that the extent of protection conferred by European patent claims is determined by the language of the claims, using the description and drawings to interpret them. That's the basic rule. But to insist on how to do that, Article 69 is itself to be understood using the protocol on interpretation of Article 69 of the EPC, which I'll call just the protocol. Article 1 of the protocol states as follows, and I paraphrase it a little for brevity. Article 69 should not be understood as saying that the protection given by European patent is defined by the strict literal meaning of the wording used in the claims, the description and the drawings being employed only for the purpose of resolving any ambiguity. But Article 69 should also not be understood as saying that the claims serve only as a guideline, and that the actual protection conferred may extend to what, from considering the description and the drawings, the patentee may have more widely contemplated as their invention. Instead, claims must be interpreted as defining a position between these two extremes, which combines a fair protection for the patentee with a reasonable degree of certainty for third parties. So, on the one hand, there is an approach in which the words used in the patent are restricted to their literal meaning, and the patent draftsman is taken to mark out the claims of the patent precisely. This approach provides a reasonable degree of certainty to third parties that the protocol refers to, but it also risks an injustice to the patentee if a minor variant that they thought they claimed is excluded as a result. On the other hand, the wording of the claims could also be taken as a guideline that aims to identify a more indistinct or nebulous inventive concept protected by the patent. This approach will provide a fair protection for the patentee, but it has the problem of leaving third parties in doubt as to the activities that may infringe. So the protocol says that both of these extremes are wrong, and that instead a middle way must be found. And the difficulty for the national courts, who have to apply Article 69 of the protocol when assessing infringement or non-infringement, is to work out exactly how to do that in a way that can be applied consistently for the different facts of each case they come across. As one English judge once put it, like the hippopotamus, the middle way is difficult to define, but the hope is that one will recognise it when one sees it. As I suggest on the previous slide, a particular concern with the literal approach is that it's likely to exclude immaterial variants, so-called equivalents. An equivalent is generally understood to be a small variation to a product or process which enables it to effectively use the patented inventive concept, but without literally infringing the language of the patent claim. This is important because a rival product or process may be able to benefit from the invention with a modification that lies just outside the claim when strictly construed. Technological advances may also later allow the invention to be used in ways not envisaged by the inventor. So in an attempt to deal with this, the protocol was revised in the EPC 2000 to add Article 2, which says, for the purpose of determining the extent of protection conferred by European patents, due account should be taken of any element which is equivalent to an element specified in the claims. Now, how due account is given to immaterial variants, equivalents, in a clear and structured way, again goes to the central issue of how patent claim scope should be determined by the national courts. And so it's to the national courts that I'll turn. But first, I should just mention that it's often remarked that the two extremes described in the protocol that I outlined are based on the two broad approaches of the UK courts on the one hand and the continental European courts on the other, respectively. In particular, it's sometimes said that the UK approach is too strict and unforgiving on patentees, and that by contrast, the major continental European courts take too liberal an approach. However, neither statement is true, I would suggest. The reality is much more nuanced than that, and the approaches are probably much closer. However, this will hopefully become apparent from what you're about to hear. So, starting with the UK, the specific mention of equivalence in Article 2 of the protocol was a source of interest in the UK because the doctrine of equivalence as such has never been considered part of English law. In fact, the approach to claims in the UK has long been and still is one of what is called purposive construction. This asks, what was it that the inventor's purpose was to claim? This must be ascertained by asking the objective but notional legal character, which is referred to as the skilled reader of the patent or the skilled person by lawyers, what they would understand the claims to mean. And to do this, the skilled reader, whose view is in reality established from expert evidence, must look at the claims in the context of the description and drawings of the patent, together with the benefit of their common general knowledge at the publication date of the patent. As a result, even when it was known that Article 2 of the protocol was going to come into force in the UK, the House of Lords, which is now the UK Supreme Court, held in the Kirin Amgen case that Article 69 EPC shut the door on any doctrine which extends protection outside the claims. Now, since Kirin Amgen, the Court of Appeal has sought to organise the principles laid down by the House of Lords in that case. 6 of these principles are shown on this slide, and they reiterate the purposive approach. You can also see that the fifth point down expressly states again that there is no doctrine of equivalence. Yet, despite this, there is a subtlety to this, which is apparent in a recent statement of the Court of Appeal in the Pemetrexed case, Actavis and Eli Lilly. And this again draws out strands of principle from the Kirin Amgen case. Here, the court said that just because there is no general doctrine of equivalence, it doesn't mean that the existence of equivalents which have no material effect on the way the invention works have no bearing on purposive construction of a patent claim. Instead, the court states, it has long been the law that such equivalents actually form part of the background of facts known to the skilled reader, which would affect what he understands the claim to mean. So in a sense, the doctrine of equivalence is wrapped up in the purposive approach. The Court of Appeal goes on to say in the Pemetrexed case that English law recognises the impact of equivalence in the so-called protocol questions. The protocol questions were formulated in earlier cases to test whether a feature of an allegedly infringing product or process that falls outside the literal meaning of a word or phrase in the claim should nonetheless be interpreted as within it. However, until Pemetrexed, they'd hardly been referred to for about 10 years in cases. So this was something of a resurrection for the protocol questions in the Pemetrexed case. So what do they say? The questions are on the slide, and they ask as follows. Does the variant in the product or process have a material effect upon the invention, the way the invention works? If yes, the variant's outside the claim. If it doesn't, then you go on to the second question down. Would the fact that the variant has no material effect have been obvious at the date of publication of the patent to a reader skilled in the art? If no, the variant is again outside the claim. But if it does, you go on to question 3. Would the reader skilled in the art nevertheless have understood from the language of the claim that the patentee intended that strict compliance with the primary meaning was an essential requirement of the invention? If yes, the variant is outside the claim, but on the other hand, the third question goes on to say, a negative answer to the third question would lead to the conclusion that the patentee was intending the word or phrase to have a slightly broader figurative meaning as a class of things which may include the variant. Therefore, while the UK courts don't recognise the doctrine of equivalence as such, there is flexibility in this further step, which allows the possibility in rare cases that a claim may be construed to include an immaterial variant or equivalent. Now, before turning to an example, I should just raise the issue of the role of the prosecution file when determining claim scope. This is something that the English courts have been rather sceptical of. The Court of Appeal has said now, again in the Pemetrexed case, that it doesn't regard it as useful for a party to argue from the prosecution history that the patentee deliberately accepted a restriction to the scope of their claim. And the reason for this is because the court says it's always open to the patentee to say simply that any concession made in prosecution wasn't actually necessary and or that it was wrongly made. However, the court does in this case leave open the possibility that there might be circumstances in which the prosecution history has some interpretive value, although it doesn't say exactly what they are. So I'll finish on the UK by describing the recent example of how the purposive approach was applied in English court, the English Court of Appeal, in fact, in Smith and Nephew and Convertex Technologies. Now, Convertex patent protected a process for the silverization of gel-forming fibres in wound dressings. But the important bit was that Claim 1 required a binding agent present, I quote, in a concentration of between 1% and 25%. Smith and Nephew had developed a competing process with a binding agent at a concentration of no more than 0.77%. So the issue was therefore whether this concentration was covered by the claimed range. There were three possible approaches argued out in court to construing the lower limit of the range, 1% to 25% binding agent, and these were, firstly, an exact values approach, giving a lower limit of exactly 1%. Secondly, the number rounding convention, in which case the number 1 covers values equal to or greater than 0.5 to less than 1.5. Or lastly, the significant figures convention, in which case the number 1 covers values of greater than or equal to 0.95% up to less than 1.5%. Now, at trial, the judge adopted the significant figures convention, leading to a finding of no infringement. That is, 0.77% falls outside the range because the lower limit is construed as 0.95%. But the Court of Appeal overturned that decision and applied the number rounding convention, leading to a finding of infringement. That is, that 0.77% falls within the range because the lower limit is construed as 0.5%. Lord Justice Kitchen in the Court of Appeal emphasised again that the critical question in English law is what the skilled person would understand to be the purpose of the words or numerals appearing in the claim. And this has to be done in the light of the common general knowledge of the skilled person and in the context of the specification as a whole. And in this case, the range was not intended for calculation or measurement, the judge held, but instead to educate the skilled person on the range of permissible binding agent concentrations. And in this context, the preferred expert evidence was that the skilled reader of the patent would understand from reading the patent that the whole numbers approach is to be used. In part, this was because various methods of expressing the precision of numbers had been used in the patent description, which emphasised that the claims were written in whole numbers very deliberately. And it was also important, the court held, that the significant figures approach would result in an error distribution which, according to the evidence, bore no relationship to the distribution or random error that would actually be expected in practice. So that's all I'd like to say about the UK. And so it's time to hand over to Judith Krens in Amsterdam to explain how the Dutch courts address scope of protection. Judith.
Yes, hi, thanks, Paul. As Paul said, I'm working in the Amsterdam office, and I will briefly tell you something about the scope of protection in the Netherlands. Let me start with the general approach. Historically, Dutch courts indeed tended to take a pretty liberal approach towards claim interpretation. Instead of focusing at the literal wording of the claims, what the court did is they tried to find the essence of the invention. In practice, this meant a broader and sometimes much broader scope than protection for the patentee than protection just based on the literal wording of the claims. When Article 69 of the EPC came into force, Dutch practice didn't change that much because the Dutch thought they already complied with 69. Only later on, there was a landmark case, the Ciba-Geigy OT Optics case, which is a case from 1995. And in that case, the Supreme Court slightly changed the test to determine the scope of protection. The Supreme Court said that it was no longer the essence of the invention one had to determine, but one had to look at the inventive concept behind the wording of the claims. And by doing so, the claims became more important. Recently, a few years ago, in 2012, the Supreme Court ruled in a famous case, EGA Occlutec, that the inventive concept shouldn't be considered as the starting point for patent protection, but as a viewpoint, which meant that it should be taken into account, but that other points could be taken into account as well. And I will come to that later on in my presentation. So back to Ciba-Geigy for a moment. And the reason I do that is that Ciba-Geigy is still considered a landmark case for the scope of protection in the Netherlands. And other more recent cases, like the one I just mentioned, should be considered as sort of a fine-tuning of the rules set forth in Ciba-Geigy. So one has to determine the inventive concept behind the wording of the claims as a viewpoint. Another viewpoint is that there should be reasonable protection for third parties. And this viewpoint may justify a more restricted or even literal interpretation of the claims. In such case, no or less attention is paid to the inventive concept behind the wording of the claims, resulting in a less or maybe less reasonable protection for the patentee. And it was in 2012 in AGA Occlutec that the question arose whether all viewpoints should be taken into account equally. And the Supreme Court said, no, that is not necessary. It's up to the courts to determine which viewpoints to take into account in order to determine the scope of protection. So the courts could actually sort of pick and choose. And what about the prosecution history? The prosecution history can play a role in determining the scope of protection of a patent, and I will come to that later in a separate slide. And what I want to mention as a last point on this one is that there could also be other circumstances, also viewpoints, which could be taken into account. And an example of such a circumstance is whether the invention is a real breakthrough invention. Because if it is, it might justify a much or slightly broader scope of protection than just a normal invention. So, on the doctrine of equivalence. In the Netherlands, we do have a limited doctrine of equivalence. But it's not that broad as some people may think it is. In principle, there should be a contextual interpretation of the claims as of the filing date. And this means that a broader non-literal interpretation of the scope of protection of the claims is possible. And it's not exactly the purposive interpretation as used in the UK, but it's leaning slightly towards such an interpretation. And this interpretation should cover equivalents which were known at the filing date of the patent. And apart from that, equivalents not known at the filing date of the patent might, in certain special circumstances, be considered as covered by the patent. And that is what we call the doctrine of equivalence. There are two separate tests which we use to determine whether something falls within the doctrine of equivalence and is therefore protected by the scope of protection of the patent. The first test is the function-way result test. And the court has to answer the question whether the non-literal equivalent fulfills the same function in the same way, having the same result. If all the answers are answered positively, if all the questions are answered positively, there might be infringement by equivalence. The other test, the insubstantial differences test, is often used in chemical or pharmaceutical cases, and there the courts tend to look whether the differences between two compounds are significant or not. One comment I have to make here is that even though we do have a doctrine of equivalence, the courts pretty rarely accept infringement by equivalence. And one of the reasons for that is that the courts pay more attention to the reasonable certainty of third parties. But on the other hand, the courts also consider that most equivalents probably will already be covered by the scope of protection in the contextual interpretation of the claims. And therefore, there are not many equivalents left which should get protection. Then, sorry, I think I have, did I miss one slide? Well, anyway, I think, I see. I changed two slides. Okay, I want to mention a few things about prosecution history. Unlike in some other jurisdictions, in the Netherlands, the prosecution file can be used to interpret a claim. It could be used to interpret some specific features of the claim, to understand what they mean, and it could also be used in order to determine whether or not the patentee abandoned part of the potential protection for a patent. So if during prosecution the patentee gave up part of its protection, then it cannot claim it later on in infringement proceedings. The prosecution history in the Netherlands can, however, not be used to argue a broader scope of protection. In a way, the prosecution history can thus only be used to the advantage of the alleged infringer. And very recently, that's the third bullet point on this slide, in February of this year, the Supreme Court considered with respect to the prosecution history that something which had been disclosed in a patent application but not claimed should be considered as disclaimed. And the Supreme Court argued that it was not required that the patentee explicitly abandoned part of the scope of protection. Then I move back one slide. Because I want to finish my part of today's presentation with two examples. The first one is the Supreme Court case I just mentioned in the context of the prosecution history. This is the dispute between Bayer and Sandoz, and Bayer had patented a method to produce an anticonceptive. The production method involved an oxidation step. And the claims mentioned that the oxidation step should take place in the presence of a ruthenium salt, which was used as a catalyst. Sandoz used an organic compound called tempo in the oxidation step, and not a ruthenium salt. Tempo was, however, mentioned in the patent application. The Court of Appeal had ordered that while Bayer didn't explicitly abandon the scope of protection for tempo, all circumstances were such that the skilled person would think that the patentee didn't wish protection for tempo. And the Court of Appeal argued, well, the circumstances which played a role were the contents of the patent itself, the prior art, the aimed goal of the patented method, additional advantages of the ruthenium salt, and the knowledge about both ruthenium salt and tempo at the time of filing of the patent application. And all should be considered in the light of what a skilled person would think, how the skilled person would understand it. So the Court of Appeal said, no, the skilled person wouldn't understand that tempo should be covered as well. So it ruled that there was no infringement by Sandoz. And the Supreme Court confirmed the ruling of the Court of Appeal. My second example slightly goes the other way. That is a case between AstraZeneca and Resolution, and AstraZeneca had a patent for the cholesterol inhibitor rosuvastatin. And the claims mentioned that the compound could be in the form of a salt. The description of the patent listed a number of potential salts. But the list was an exhaustive list. The zinc salt, which Resolution wanted to use, was not listed in this list. But the Court of Appeal, however, ruled that the patent related to the new active compound, rosuvastatin, and that the patentee didn't have the intention to limit the scope of protection to certain salts of such active ingredients. According to the Court of Appeal, this would be clear to the third party. So again, the third party, or the person skilled in the art, was the most important person here. What would he or she understand? And as the third party would not consider that the patentee wanted to limit its scope of protection, a wider scope of protection than a mere literal protection was justified. So this involved a contextual interpretation of the claims. The Court of Appeal didn't rule on the doctrine of equivalence. I should say that this case is currently under appeal with the Supreme Court. I don't know exactly when we can expect a judgment, but I would say somewhere first half of 2017. I will leave it with that, and I will hand over to my colleague Christof Höhne in Düsseldorf.
Yes, thank you very much, Judith. So now in my part of the presentation, I will introduce to you the German approach, in particular to the doctrine of equivalence. So first of all, the claims are the decisive basis for determining what is protected by the patent. And this, of course, applies to literal infringement, but also taking into account Article 2, already mentioned by Paul of the protocol, requires that variants are taken into account. So in Germany, we have a discrete and separate doctrine of equivalence. As already pointed out, the general idea is that it is almost impossible for the inventor to draft the perfect claim which embraces everything which he invented. So in order not to deprive him, one should also look to the left and right of the claims. As you can imagine, the principal problem with that is, of course, legal certainty to the public who wants to know what is exactly protected by the patent and what not. So in any case, when we look at the patent claims, we go beyond a literal construction. The use of the prosecution file in general is not permitted in Germany to determine the claim scope. So when we look at the doctrine of equivalence, a three-step test was devised that has to be met in every case. The first decision on this, and the guiding one, is the Schneidmesser cutting knife 1 decision, as it's called. So to find that the doctrine of equivalence is fulfilled, 3 criteria must be met. The first one is the question, does the modified embodiment solve the problem underlying the invention with means that have objectively the same technical effect? So this is more or less an objective criterion. The second question is then if the person skilled in the art, using his specialist knowledge, was able to find the variant at the priority date as having the same effect. Basically, that the attacked equivalent is non-obvious, or it's obvious if you read the description. This is also still a rather straightforward criterion, but now turning to the third criterion, it gets a bit more complex. So the question here is, are the considerations which the skilled person takes into account for the variant close enough to the considerations taken into account for the literal solution, such that the skilled person will consider the variant as a solution which is equal or equivalent to the literal one? So basically, it's a very subjective criterion, what the person skilled in the art thinks when comparing the attack equivalent with what is in the patent claim. As this has led to a lot of uncertainty, there's been some rather recent case law of the Federal Court of Justice on this criterion and on the doctrine of equivalence as such. So one of the first cases, the occlusion device case, I think was already mentioned by Judith. It also had a Dutch part. This case was around a stent-like product which could be used in blood vessels to block these. The claim wording itself, which focused on this occlusion device, required that this occlusion device had at its respective ends clamps that would hold it together. Now, in the attacked embodiment, there was only one clamp at one end. On the other hand, a clamp was not required because of the specific mesh structure when it was deployed. So the question was if this, of course it was not a literal infringement, could be an infringement under the doctrine of equivalence. The first instance court in Düsseldorf and also the appeals court held that yes, this was an infringement under the doctrine of equivalence because it looked into the description of the patent that, okay, the claim wording, the literal infringement would be to have these clamps at the ends, but when reading the description, they found an alternative which also states in some cases that only one clamp would be required if the construction of the mesh would be in a certain way. So it held that the doctrine of equivalence would apply. This case, however, went up to our highest court, the Federal Court of Justice, and it held that the doctrine of equivalence does not apply in the present case, and specifically turning to the third criterion I just mentioned. Because in the case at hand, the court noted that discrete alternatives were mentioned in the description. So when one looks at the description and sees these alternatives, it has to be noted that these were not expressly included in the claim wording. So just by listing these in the description of the patent, it was shown that the inventor was aware of these and for whatever reason chose not to include them in the claim wording. So in this specific case, the Federal Court of Justice applied a new theory stating what is disclosed in the description but not expressly claimed is disclaimed, applying basically a waiver for protection. The inventor was aware of it, but for whatever reason did not include it in the claim. A little bit similar to perhaps a selection invention where you have several alternatives and you pick out just one alternative and list this in the claim. So the big discussion after this decision was if the doctrine of equivalence was still alive or if it was dead, because customarily one would look into the description to find out what the inventive concept was, and if it was broader than what was covered in the literal claim wording, one could also include alternatives in the doctrine of equivalence. But as now pointed out, this was no longer the case. So another case then following this decision came up to the Federal Court of Justice, and this related to a specific method for the production of a reagent which could be used for isolating polymers. And in one of the steps of production for this reagent was required to have an epoxidation by means of a diglycid binding. However, the attacked embodiment or the attacked method only featured a mono binding. So the question was if this was also an infringement under the doctrine of equivalence. Now the first and second instance court, before it went up to the Federal Court of Justice, held that yes, this would fall under the doctrine of equivalence. The Federal Court of Justice held that it could be the case, but nevertheless remitted it to the second instance court, the appeals court, because it held that the legal assessment the court took was wrong. So this involved a situation where you had one alternative which was listed in the claim, literally, and in the description you had a literally disclosed alternative. And the attacked embodiment was somewhere in between. And the Federal Court of Justice said, I remit the case and you court have to decide if it is closer to the alternative mentioned in the description, then it would not be an infringement under the doctrine of equivalence, or if the attacked embodiment would be closer to the one that is claimed in the patent claim itself, then it would be infringement under the doctrine of equivalence. So, although it was, of course, the purpose of the Federal Court of Justice to provide some more light on the application of the doctrine of equivalence and perhaps more legal certainty, this recent jurisprudence has raised a lot of questions which we will turn to again in a minute. But of course, the most decisive question is, when I look at the description and I look at alternatives, how well do these alternatives have to be disclosed? Does it have to be an exemplary embodiment, or can it just be that some other alternative, which is rather vague or general, is also an alternative and automatically falls out of the scope of the doctrine of equivalence? So I just wanted to give you this brief update on this more or less recent case law and turn to a comparison. Now, Paul has already pointed out the protocol questions that particularly played a role in Pemetrexed case, which I will come to in a minute. And just when we compare the test that is applied in the UK and in Germany, it can be noted that it is strikingly similar, if not identical, at least on paper. So our first question for the doctrine of equivalence would be, does the modified embodiment solve the same problem underlying the invention with means that have objectively the same technical effect? Whereas the UK would ask, does the variant have a material effect upon the way the invention works? So basically, it's the same question. The same applies to the question if it was obvious for the person skilled in the art to come to the variant. So in Germany, it is asked, was the person skilled in the art using his specialist knowledge able to find the variant at the priority date as having the same effect? Whereas the UK asks, would this variant have been obvious at the date of publication of the patent to a reader skilled in the art? And then we come to the third question. Again, I mentioned this is the very difficult one, but it's strikingly similar in the UK. So in Germany, we ask if the person skilled in the art, when comparing both the equivalent, a potential equivalent, and what is claimed, would consider these similar, and the approach taken in the UK is the same, at least on paper. But as I mentioned already, the more recent German case law with the waiver has to be taken into account. And just to make this a bit clearer, I want to turn to a practical case, the Pemetrexed case, which Paul already mentioned. So in a nutshell, this case related to Eli Lilly's patent EP 508, which related to the use of Pemetrexed disodium in combination with vitamin B12 and optionally folic acid for inhibiting tumor growth. Now, in the prosecution history of this patent, the word Pemetrexed disodium, right in the preamble of the claim, was not at first included. At first, it was stated just an antifoliate. Then, after the examiner said no, that this would not be sufficient, turned and changed to Pemetrexed, and then, for whatever reason, it then changed into Pemetrexed disodium. So the question was now, which in this case Actavis was asking, if its product it was envisaging would infringe the product. The product of Actavis did not have Pemetrexed disodium, but Pemetrexed dipotassium. Both cases, they were fought in the UK, France, and Germany. And turning to the UK and Germany, at first we see more or less the same result. So just to explain the German side, the first instance court found infringement by the doctrine of equivalence. The appeals court, however, reversed this decision and said, turning to the three-step test, I don't need to look at the first or the second question in the three-step test because I already know that the third step is not met. So when the person skilled in the art compares the equivalent with what is claimed, he clearly sees that something different was claimed. And in particular, if I, now the appeal court, apply the recent waiver jurisprudence of the Federal Court of Justice, I note that the patentee had confined its protection only to Pemetrexed disodium and has disclaimed all other forms of Pemetrexed because the description mentions more or less generically Pemetrexed or antifoliates as a class of compounds. The Düsseldorf Appeal Court held that just the general disclosure of antifoliates and Pemetrexed would disclose all other individual compounds of this class, which would be disclaimed. In the English court, first instance and second instance, it was also found that there was no infringement by doctrine of equivalence. Of course, we know, as Paul already pointed out, this is assessed within the actual literal claim scope. So it was held that the material effect would have been the same, but on questions 2 and 3, which are highly similar to the German questions, sorry, I should go to the slide. It was held that the person skilled in the art would not consider this obvious when reading the description, so he would not consider dipotassium to be the same as disodium, and also when comparing disodium and dipotassium, he would not consider these to be in any way equivalent. However, on the German side, this case went to the Federal Court of Justice. And the Federal Court of Justice took issue with the decision of the Düsseldorf Appeal Court, which was more or less identical to the one taken in the UK, that there was no doctrine of equivalence. It basically stated that the Düsseldorf Appeal Court was wrong when which just focused on the third criterion, by stating that a disclosure of a class of compounds would be a waiver for all compounds not being Pemetrexed disodium. The Federal Court of Justice said that this disclosure was just a class of compounds that were disclosed. It was not a clear alternative, for instance, as an exemplary embodiment or the like. So just this very general disclosure of a Pemetrexed or antifoliate does not mean automatically that all other Pemetrexed besides disodium would be excluded from protection. In this way, it held that this case was different to the ones it had decided before, and that there was no clear alternative which could be considered disclaimed. So it remitted the case again to the Düsseldorf Appeals Court to decide on the first and second criteria. Interestingly, also referring to the judgment of the UK Patents Court, stating that the Düsseldorf Court should especially focus on the second criterion if the person skilled in the art, when using a specialist's knowledge, was able to find the variant at the priority date. So if this was obvious or not, because it already foreshadowed that this could be seen critically in view of the UK approach to this. So as a result, I will just wrap up from the German point of view that it's close to the UK approach, but it has some differences, especially regarding a waiver for protection. And now I hand back to my colleague, Paul England.
Thank you very much, Christof. So in summary, what common ground can be drawn from these national approaches to determining the scope of protection of claims? Although parallel cases can be found in which the Dutch, French, German and UK and indeed other national courts come to different decisions, all the jurisdictions have an approach in which the claim language is central, but where allowance can be made for including within protection certain features that fall outside the literal wording of the claims. And this is in keeping with the common principles that the systems share in the form of Article 69 and the Protocol. However, in practice, certainly in the 3 jurisdictions we've looked at, I think it's fair to say that even in those countries where there is a recognition of doctrine of equivalence, its application is used as something of a last resort to avoid an unfair result. Consequently, and subject in Germany perhaps to how the most recent decision that Christof has been describing plays out, a decision that a variant lies outside the literal scope of a claim is probably going to be the rarity in the national courts. Now, with that summary, it just reminds me to thank you very much for joining us and to thank my co-presenters. Please do wait a moment for our survey to appear, and please also look out for further webinars. We'll be talking on European patent law issues again, but first, on the 15th of November, we're going to be presenting a webinar about regulatory data exclusivity. So please join us if that interests you, and goodbye for now.